Welcome to the Business Restructuring Podcast with Parkins and Rubio.
Hello, everyone, and welcome back to the Business Restructuring Podcast with Parkins and Rubio. Leonard Parkins and Charles Rubio are corporate bankruptcy and financial restructuring attorneys with offices in Houston and New York. They represent companies, lenders, and stakeholders in complex restructurings where litigation risk and financial pressure intersect. I'm Sean O'Connor, and today we're continuing the series From Defense to Offense, Strategic Playbooks for Companies Under Pressure, with a conversation about how Chapter 11 can rewrite the rules of litigation and shift companies from defendant to decision maker. All about using Chapter 11 as a strategic tool and the benefits of that. Leonard, Charles, good to see you both.
Good to see you.
Good to see you, Sean.
Let's, I'm fascinated by this in terms of the Chapter 11, and on the one hand you've got the stigma, on the other hand you've got just like a myriad number of benefits in using it strategically. What changes immediately after a company files Chapter 11? In the middle of significant litigation, especially in terms of control and timing.
First of all, there's an automatic stay. There's a statutory injunction created, and it's called the automatic stay. It's well known. And it's been in existence since the Bankruptcy Code came into existence in 1978. It is an automatic stay of the continuation of any litigation against the company, continuation, stopping any collection efforts against the company, and basically major litigation against the company simply stops. There's a federal statutory injunction without having to go to court. Upon the mere filing of the Chapter 11, you pay the fee, you file the bankruptcy case, the injunction goes into place. So the first thing that happens is what's called a breathing spell happens. The litigation stops, parties go home, the litigation is put to rest for a while, and the matter goes before the bankruptcy court as to how that claim and other claims against the company will be handled. And the debtor changes from a defendant to what's called a debtor in possession, and the debtor in possession runs the bankruptcy case, is in charge of the bankruptcy case, controls the bankruptcy case, and in fact is given statutory exclusivity to run the bankruptcy case and determine how creditors are paid under a plan. Charles, what do you think about this? What happens?
Yeah.
What else happens?
One of the immediate effects, together with the automatic stay, with what Lenny described, where we're often, noticing out specific parties right after we file. So they're on notice that there's now an automatic stay, and our clients want us to know that. But another huge advantage, and that's an automatic advantage, is that if there was any receiver appointed in state court litigation over the assets of this company, then the act of filing the case itself divests the receiver of that property and puts it back in control of the company and the debtor in possession. So it is possible for the receiver to go in and try to get leave of that. But in the initially, all of that property goes back to the debtor statutorily under the Bankruptcy Code. So that's an immediate effect of filing for bankruptcy, just a consequence of just filing the petition.
And these are issues of basically federal preemption, bankruptcy law preemption of state court. For example, the receiver Charles talked about, receivers are appointed in state courts for a number of reasons. They are statutorily divested of power and ordered to turn over their property to the debtor in possession, absent showing by the receiver there's some reason the receiver should stay in place, which rarely happens, but that option is there. But it will divest the receiver, for the most part, of any position, control, right to run the property of the debtor that existed pre-filing the Chapter 11. That's a big power, big statutory right that the debtor in possession has.
Another administrative feature that you get right when you file is that creditors have an opportunity to file claims against the debtor. And there'll be a formal, what we call a bar date, implemented in the case, which makes them file it by a date certain. Otherwise, it's barred. So anytime after the case is filed, creditors can start filing their claims against the debtors. We call that proofs of claim. And just as a result of this, though, they're also subjecting themselves to the jurisdiction of the bankruptcy court, and they're bringing those claims to a centralized forum, the bankruptcy court, where the debtor elected to file its Chapter 11 case. It's bringing all of those claims into one court, and that happens immediately just by virtue of filing and having that administrative overlay of claims in the bankruptcy case.
Let me give you an example. If you had a $10 million state court lawsuit that was filed and pending at whatever stage, let's assume a relatively early stage, the company defendant files Chapter 11, that lawsuit will be stayed. Those claims in the lawsuit will be embodied by statute in what's called a proof of claim. When they submit a proof of claim and have to file a proof of claim under the statute in order to participate in the assets of the company in Chapter 11, they waive their right to jury trial. The filing of the proof of claim submits them to the jurisdiction of the court and is a legal waiver of the right to jury trial. An immense power shift, taking away jury trial right in civil litigation and making them file a proof of claim and waiving the jury trial right. The consequence of that is their lawsuit may say actual and punitive damages requested. They will file a proof of claim and they may say actual and punitive damages requested. There really is no such thing as punitive damages being awarded in a bankruptcy case. Punitive damages are frowned upon as taking away actual money that creditors might have for real claims throughout the system of the bankruptcy case. So punitive damages probably are not going to be part of any further equation for the plaintiffs. So you take away the jury trial right, you take away the punitive damages, you force them to a trial and a judge in a venue you pick. The debtor picks. Very change of dynamics.
So as the debtor, am I able to, I can pick the state?
Well, here's an example. The bankruptcy venue statute, it's a federal statute, part of the bankruptcy code, allows debtors to file bankruptcy in the principal place of business or where they own their major assets. There's also another provision that says a Chapter 11 company can file Chapter 11 where an affiliate files Chapter 11. It's called the affiliate rule. And interesting enough, if you remember, Eastern Airlines went into bankruptcy, but there was no Eastern Airlines bankruptcy case. It was called the Ionosphere Club. And the Ionosphere Club was a club where people went and waited for their planes. Ionosphere Club was an affiliate of Eastern. It was created and headquartered in Manhattan. It filed first, and then Eastern Airlines, headquartered in Atlanta, filed. So the case was styled Ionosphere Club. Eastern was a second company under it and stuff like that. So similarly, you can create venue by statute of an affiliate, put it in a venue you choose to be, file that affiliate, and then file the mother company, the big company, in that venue, and therefore having picked the venue you want to be in and have your case tried in with whatever federal judges, bankruptcy judges would be presiding in that venue, in that district. A remarkable power prescribed by statute, which takes the venue that the plaintiffs want and moves it to the venue where the defense wants through Chapter 11.
Right. And presumably for a more favorable outlook, whether it's in terms of knowing who the judges are and what their previous rulings have been, that sort of thing?
Well, that's number one. It gets away from the plaintiff's venue choice, which is usually in a very favorable venue where verdicts come in high against the defense, number one. You don't have a jury trial. And number three, you get to pick basically from a coterie of judges who are presiding in that federal district to try your case. Most of them fairly sophisticated, most of them very experienced in business litigation, and who can effectively and efficiently deal with these kinds of situations.
Got it.
And Sean, there are some favorable courts around the country that people do try to file for bankruptcy in. Like certain courts are known to have sophisticated jurists as the judges, and they choose to file in certain places. So getting venue in those courts is oftentimes something the companies want to do, and part of this goes back to the planning, and getting in ahead of time and being able to implement a proper strategy. But part of that is, like what Lenny says, where's your principal place of business? Where's your management team? Sometimes you want to refocus and move those things around in anticipation of a Chapter 11 case. And I had a case where the management team was on Fifth Avenue, like one of the partners, and one of the partners was in West Texas running oil and gas assets. And we filed in in New York, and because the manager is walking essentially down the street from Fifth Avenue to the courthouse, venue is perfectly proper in that court. And even though all of the claimants had a buy from Texas, and were kind of annoyed with that situation, it was a proper venue to stay in. So that's an example of getting to kind of pick your venue.
Yeah. So once litigation moves into bankruptcy court, how do those adjudication dynamics differ from the jury-driven litigation, Leonard?
Well, the way it usually works is that the plaintiffs, using an example, the plaintiffs who have a lawsuit pending have a claim for, let's say, breach of damage or a class action claim for some wrong alleged against the company. Those claims will be subjected to the bankruptcy court jurisdiction by virtue of what Charles identified, the filing a proof of claim.
Mm-hmm.
The way you bring your lawsuit against the debtor is to say, I have a claim against them for the debtor for doing a wrong, breach of contract, commercial tort, whatever it might be. And that claim is filed pursuant to what Charles described was the bar date order, an order saying you must file your claim by such and such a date. And most of these orders say, if you don't file your claim, you get notice about it, you don't have a claim against the company. So the litigation then begins as a proof of claim. For example, you file proof of claim against the company saying the company owes you $5 million. The company then has the opportunity to object to that claim. In other words, answer the lawsuit you bring by a proof of claim. I object to that claim. The issues you would have tried in the lawsuit as defenses will be raised in an objection to claim. You're also allowed as a debtor to bring a counterclaim, as you would be in the state court, to seek affirmative relief against the plaintiffs who filed a proof of claim, and bringing what's called in bankruptcy court an adversary proceeding, which is a lawsuit in the bankruptcy court. So you have the ability to raise your defenses to a proof of claim, defenses to a lawsuit equivalent to that, and you have the right to bring a counterclaim against the claimant, okay, as you would in the state court to seek affirmative relief. So both those options are available in the bankruptcy court. They're just called something else, but they will be tried in the bankruptcy court. They will be tried before a bankruptcy judge.
I get it. The obviously claims in Chapter 11 are handled differently than traditional lawsuits. What about it's the creditor-driven process. How does that change the leverage? When you make that shift.
Yeah, I mean, at that point, it's not, the creditors don't, and their plaintiffs' lawyers don't really control the momentum of the case. You do as the debtor. So you're setting up the bar date order, forcing them to file claims. You're deciding when to make objections to that claim and raise that issue. You're setting the momentum of resolution ultimately of that claim on your terms, and those lawyers don't, and those parties don't have the ability to even really do anything to advance their claim and the liquidation of their claim until really the debtor is ready to do it. So the debtor picks when it wants to object to claims and ultimately have those claims resolved.
I give you another example in a class action situation where class action is filed or to be filed, and no class has been certified yet. Bankruptcy case is filed. An objection to there being a class claim, objection to being a class action claim is made by the debtor. Generally speaking, early enough in the case, before a class is certified in state or federal court class action litigation, the courts will deny the right there to be a class action. They will say that the bankruptcy is in fact a class action. Everybody gets to file its claim against the debtor. Everybody who has a claim can bring it before the court, and therefore, there's no class claim, there's no class action. The significance of that is that the plaintiff's lawyers who look to make a substantial recovery on their own for representing a class are divested of that opportunity. That disincentive is a huge disincentive. Now, on the other hand, there is a representative for the creditors. It's called the Creditors Committee in a Chapter 11. And the Creditors Committee hires a lawyer and financial advisors to represent the interest of all the general unsecured creditors as a whole, but they don't get an incentive compensation as the plaintiff's lawyers would get in a class action. So that is another tool, weapon, incentive to use Chapter 11, okay, to sort of deactivate the class action protagonists in the state and federal court.
That makes sense. I want to ask, I mean, probably only time for one more question here. I know, Charles, you had, this is kind of around strategy, negotiation strategy. Charles, you'd mentioned the bar date, right, which forces claimants to, act within a defined timeline, sort of speak now or forever hold your peace kind of a thing. How does that deadline affect negotiation and strategy?
Like that, I wouldn't say that necessarily affects negotiation strategy. I mean, like that is an important deadline to make sure the company knows the universe of all the claims that are being asserted against it, and then it can develop its own strategy on how to respond to that. There might be instances where there's common claims and you kind of group them together and you do like an omnibus objection to handle multiple things at one time. So you're gaining some efficiencies by having them all there and all set forth by this date certain. So you can then come up with your kind of efficient litigation strategy on how you want to deal with all those claims. So I think that's probably like the economies of scale, like I'm talking about, is the most important thing that the bar date's doing for the debtor as far as controlling the claims being asserted against it.
If I could just give one quick example. 20 years ago, there was a case called Seismograph Services. I was called on a Friday morning to file a Chapter 11 for a company called Seismograph Services because on Thursday, a jury verdict had come in South Texas for $100 million actual and $400 million punitive damages, and the judge is going to sign the judgment on Saturday morning. We filed Chapter 11 on Friday night and stayed the litigation. The judge couldn't sign the order. The plaintiffs came into court and said, "Your Honor, we have a judgment to be signed." And the judge said, "But most of the judgment is punitive damages." And he said, "Yes." And then the plaintiff's lawyer, bankruptcy lawyer, said, "We have to file a proof of claim and we'll waive our right to jury trial if we do." And the judge said, "You're right. That's what you're going to do." And they realized they were going to have to retry the case without a jury trial. Seismograph was owned by Raytheon. Instead of $100 million and $300 million, the matter settled for less than $100,000.
Wow. Yeah, I think that sounds like one of those examples of the affiliated company.
Yeah.
Right? So
yeah, they were looking at Raytheon to pay Seismograph's exposure. But because they would have to go to trial in the bankruptcy court where there were no punitive damages, and that was the majority of the anticipated judgment, they settled the case quickly.
Well, man, we could go on and on in the nicest way, but we're out of time for this episode, guys. Always a pleasure talking to you, and I look forward to future conversations.
All right. Thank you, Sean.
Thank you so much. Take care.
You bet. That's it for today's episode of the Business Restructuring Podcast with Parkins and Rubio. If you'd like to learn more about Lenard Parkins and Charles Rubio, you can visit their website at parkinsrubio.com. And be sure to leave a review, and subscribe to the podcast so you don't miss the next episode in the series, From Defense to Offense, Strategic Playbooks for Companies Under Pressure. I'm Sean O'Connor. Have a great day.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.